disabled 16-year-old who's not equipped to face the trouble in which he finds himself and isn't getting much help. Whatever his personal failings here, there have been a series of systemic failings that are deeply troubling if you think about them too much or take them personally. Yeah, I'm not sure that I'm doing fully what I should be doing when I'm worrying about whether other people who are not in my charge are being ground up and spit out by this system, or being treated unjustly. I need to worry about whether Stephen is single-mindedly about that, I think, in some way.
Hey everybody, welcome. Roxana, Mystic Jinx, Carol, welcome. Yeah, I'm sorry I missed the first scheduled live. I was sleepy. So Brendan called this morning. He usually calls me at like 7:20. I couldn't sleep last night for the life of me, so I took Benadryl, and it knocked me out eventually when I finally got to sleep. Like, I read for a little bit, and then it knocked me out, and then but I didn't get to sleep until last time I remember looking at a clock. It was like 2:30 in the morning, and then I wake up naturally between 5 or 6 o'clock, anyway, mostly to use the bathroom. But like, I woke up and I sat up and I waited until 7:20 when Brendan called. So and then after that, I was like, well, I should start getting up and getting going because I got live in a few hours. So let's get the coffee going. And I literally rolled over and went back to sleep. So I slept until, what was it, 10:50. So I was clearly very late, and I apologize, but I'm here now. I have my coffee. And I ate some food, so I'm good. And yeah, so my internet still sucks, so I can't pull up on the screen the transcripts, but I am reading from the post-conviction motion hearing day 2. I'm on page 197, and I have these files in our Discord. The description is down below, but you can also go to foulplay.site, or you can go to StephenAveryFiles.org, I believe it is, and you can get the same, transcripts. That's where I got mine from. So, yeah. So I'm just going to go ahead and start reading from where we last left off. We're talking, so far, Mr. Drizzen, Brendan's lawyer is cross-examining their first, not their first, but Dr. Richard Leo, whom, if you guys have been following along, is an expert in coerced confessions and police interrogations. He's very highly esteemed in his field. He works, I believe, in San Diego. I could be very wrong about that part, but very, very well known in the criminal justice system, and he sat through it seems like thousands of interrogations where he's monitored them, and some of them were with guilty people and some of them were not. So he's seen it all. And anyway, he was called by Brendan's team during the 2010 post-conviction hearing. And I think I just want to kind of, because somebody was asking me this a little bit ago, and they said, well, why hasn't Brendan gone for ineffective counsel? This is part of that. In this post-conviction hearing, that one of the things that they were trying to do was go for ineffective counsel. They were basically trying to get a retrial for Brendan, or have it completely thrown out on the basis of ineffective counsel and other things. That didn't happen, obviously. The 2010 post-conviction hearing, he was denied all that, and then and then it went on to Seventh Circuit and blah blah blah. So all the way up to the Supreme Court. This is kind of what Stephen's going through right now. That we're seeing it. Stephen's attorney, Kathleen Zellner, is trying to get this hearing that they're doing right now, that we're discussing right now with Brendan. So, but a little bit of foresight into what Stephen's road is going to look like. Because if the judge grants the hearing, which we're all hoping he does, or she does, sorry, the judge is a female. She grants the hearing, and then Zelda has an opportunity to bring forward a lot of different stuff that she has, and then it's the judge's decision if there should be a retrial, if whatever. So that's basically the process that Brendan went through. Unfortunately, it didn't end very well for him because it went all the way up to the Supreme Court, like it should, and the Supreme Court of the United States of America denied it, and now Brendan's back at square one. So anyway, so we're on page 197, day 2, and we have at the very top of the page, this is where we left off, where it says take 10 minutes. And the court went to recess for 10 minutes, and then they came back. And then, all right. The court says, proceed, Mr. Drizzen, and then Attorney Drizzen. Question. Dr. Leo, is the process of psychological interrogation complete when a person makes his first admission? And the answer is no. Question. Okay, what happens next? Answer. Well, this is the post-admission phase that I referred to you earlier, where detectives. And then he interrupts him and says, I don't need you to define it right now, but you're referring now to the post-admission narrative about which you testified earlier. And he answers correct. Question. Okay, why is a narrative important in the process of psychological interrogation? Answer. To get an account of how and why the suspect committed the crime, and to also see if there's indica, I think it means indication, of reliability or unreliability, as I described earlier. I'm going to highlight this word real quick and see if it's an actual word or if this was, so hold on. Oh, it is. It's an actual word. I just learned a new word, guys. And the indicia. This is the word, indicia. I just learned a new word. It means signs. Indicia. To get an account of how and why the suspect committed the crime, and to also see if there's any indicia of reliability or unreliability, as I described earlier. What do you have there? No. Sorry, hold on. Bad girl. Here. She got a pen. She was going to chew a pen on my bed. I'm sorry. Okay. Question. Do police officers receive specific training on how to create a persuasive post-admission narrative? Answer. Yes. Question. And what kind of training do they receive? Answer. Training about hold back information, not giving a suspect non-public details that only the true perpetrator would know. Direct telling police interrogators to solicit a full account, not to stop with the admission, but to try to get full detail. Telling interrogators to look for corroboration and ways of objectively verifying and strengthening the admission. Question. How about are they trained to also seek an apology from the suspect? Answer. Yeah, that I think of that as interrogation technique. Yes. They often sometimes they're taught, and sometimes you see increasingly getting apology notes from suspects. Question. How about eliciting some type of motion? Hold on, let me refresh this because it's fuzzy for me. I don't know why it's doing that. I want to make sure that's the right word. Motion. Motive, see? Motive. So the same, some type of motive. Yes. Question. Okay. Are there any other details of the confession that police officers are trained to elicit through the post-admission narrative process? Answer. Well, the details again of how and why the suspect committed the crime. Sometimes you also see, in addition to motives, hold on. It's the internet. I'm sorry. Applause. Hey, Yoris. Trying to get a story of what happened. And sometimes in post-admission interrogation, they also will ask them legal questions. You know, I didn't make you any threats. This is voluntary. Question. Okay. Now, how does the post-admission narrative relate to the reliability of the confession? Answer. The post-admission narrative can potentially tell you a great deal about the reliability of the confession if the person is not contaminated by the police or other influences, but it can't give the non-public facts, guesses, and gets things wrong. Can't lead the police to missing evidence, can't explain aspects of the crime. If the post-admission narrative doesn't fit with the existing physical, medical, or other credible evidence, all of that indicia of unreliability. Conversely, if all of that were not true, it would be indicia of reliability. If they know non-public details that they're not likely guessed by chance, and they're not a product of contamination. And almost certainly you have to have participation in or have been present for the crime. If their statement led to new or missing evidence, matched the physical or other credible evidence, the post-admission narrative that follows the admission can become excellent evidence of reliable, or indicia of reliability. I have to refresh again. Question. Are you aware, Dr. Leo, that the prosecution in Brendan Dassey's case argued to the jury that there were 19 facts in Brendan's confession that were corroborated? 19 facts. Answer. I thought there were 17. I must have been mistaken. So I was aware that they made that argument, whether it was 17 or 19. Yes. Hi, Cherie. Question. You're referring to 17 in Mr. Buckley's report? Answer correct. Question. Okay. But neither event, whether it was Mr. Buckley or the prosecution, you understand that they argued that this was a highly corroborated confession. Answer. Correct. Question. And you are aware that they argued that Brendan's statement was reliable because it led the police to the discovery of evidence that they had been unknown to them prior to the confession. Answer. Yes. Question. And that would have been a bullet in, or the fragment of a bullet that was in the Avery garage. Answer. Yes. Question. Okay. And that it contained a description of some unusual and some mundane elements of crime. Answer. Yes. Question. How can a confession that is so rich in detail that appears to be corroborated, which leads the police to unknown evidence, be unreliable? Answer. Well, perhaps. The counterintuitively, most false confessions are very detailed. The fact that a confession is detailed does not make it true, necessarily, or false. Both true and false confessions can be detailed. The question becomes, where did this information come from? Did it come from the media? Did it come from the community gossip? Was it publicly known? Did the police explicitly feed the suspect? Or did they ask forced questions? Or did they ask forced choice questions where the answer was implied? Or did the suspect independently volunteer this? Sorry, every time I pause like that, it's because I have to refresh again. This information. So I guess to answer your question, a unreliable or false confession can be detailed with these kinds of facts. False confession. Because the person has contaminated because they learned the information from either the police or the media or some other source. I have full belief that every detail that Brendan had in his head was either from, and this is my opinion, from the media, from word of mouth from his family, as in, the police were asking all the family members questions and giving them information, right? So I believe that a lot of the family was probably discussing this stuff, and Brendan, overheard some stuff. So he plugged it in later, to the coerced confession. And the media, so the family, even the police. So there was a lot of contamination, if you think about it, that Brendan received. Like even from the RAV. Brendan knew about the RAV from the news. I believe even in O'Kelly's thing, O'Kelly tried to talk to him about the RAV, and Brendan corrected him on something I think that he heard from the news, which was more correct than what O'Kelly was trying to tell him. If I remember correctly, it was towards the very end of the video. I would have to watch it again. But because of that information, it probably made Brendan look like, yeah, he does know something. But that's not the case. When you have a whole family going through something together like that, and then the police officers, are telling them details that you're trying to plant into them, and they're going to talk about it, So, question. And in fact, aren't those studies of proven false confessions where suspects have been given what appear to be highly corroborative details accounts of heinous crime? Answer. Yes. Question. And what studies are those? Answer. And I'm here. I've written about this in my book. Professor Brandon Garrett of the University of Virginia has written about that. He has unique access to DNA exonerations, of which 40 or 50 involved false confessions. He looked at the trial transcripts of those cases, and in all but one, there was contamination. These are people proven innocent by DNA who nevertheless convicted. I'm going to Professor Brandon Garrett of the University of Virginia. I'm going to highlight that, and if you guys want to, I'm going to look this up later, but I am going to post this as a comment. So if you guys want to also look up this person, oh, that's not 3. Look at how it translates for me. Like, I copied it and it said Brandon Garrett. And it looks like 3R AR period DON. Hi, Facebook user. But that's Brandon Garrett of the University of Virginia, and he wrote a book too. And a leading scholar of criminal justice outcomes, evidence, and constitutional rights. Hey, Megan! And he wrote a book. He wrote many books. Convicting the Innocent, where criminal prosecutions go. Yeah, he wrote. Do you want us to get a link to his book? If you want to, yeah, go ahead and drop it. If you guys are interested in reading, that's another book I would be interested in reading. Yeah, I'm on his actual website here, and here's his website for all his books are. If you guys are ever interested in reading more source material, it looks like there's a lot of different books that he wrote. End of Its Rope: How Killing the Death Penalty Can Revive Criminal Justice. Too Big to Jail: How Prosecutors Compromise with Corporations. Convicting the Innocents. This is where I would think to read too. Where criminal prosecutions go wrong. Autopsy of a Crime Lab. Ooh, Federal Habeas Corpus. That would be interesting. Death Penalty. Oh, Concepts and Insights series, The Death Penalty. So it's got a bunch of like really interesting books that you can buy. Oh, paintings too. Does he paint? Thank you, Cherie. Does he paint? Oh, he does. He has a painting here of figs. And my internet's slow. Oh, and pizza. He's got a painting of pizza. So this must be his oh, he's got some after Katrina. Oh, Convicting the Innocents. Okay, yeah. So that's a good book. Then maybe we can read that after the other book that we're reading on Mondays. Demonstrations. Yeah, so he's an artist. That's cool. That's cool. So, yeah, that is cool. Yeah. How people give up because it takes so long to overturn a conviction, right? That's got to be hard. I think I remember that she quoted that it's like every time a visit every time an inmate gets a visit, it's like a breath of air for them. So you got to think that if somebody hasn't been visited in a while, they're drowning. And I agree with that in some ways. I had a friend, Devin, who was incarcerated, not wrongfully convicted, but he was incarcerated and he was doing his time. And he basically he was telling me that it felt like he was a living ghost being in prison, because everybody in the world is moving on in life, and you can't move on anywhere. Like, what are you doing? You're stealing that. She took my blanket. But yeah, anyway, I lost the track of thought because my mom came in here. Okay, I'm going to go ahead and read. Let's read. Okay. Professor Brandon Garrett of the University of Virginia has written about that. He has unique access. I already read that. He's looked at trial transcripts of those cases, and all but one there was contamination. These are people proven innocent by DNA who were nonetheless convicted. And at their trials, the argument was always made, it's a detailed confession. The person, refresh. The person supplied details that only the true perpetrator would know, and so it's corroborated. And in fact, these were false confessions, probably false through DNA. Professor in England, a professor in England, I'm not even going to try to say this name. I'm just going to post it in the chat. I don't even want to attempt that. I think was the first to really document and study this in English cases. That's the name that he's saying. So this is a phenomenon, and I've written elsewhere about it with my colleague Richard Offshay. This is a phenomenon that's well known to confession researchers, especially with these DNA cases. Question. Now, contamination that you're referring to can come from a variety of sources. Answer, correct. Can it come from the police? Correct. Can it come from the media? Correct. It can come from the suspect's general knowledge of the crime scene, as in you lived in the house that the crime was committed in, right? Correct. In many cases, for example, suspects will come upon a dead body that will give them information they could contaminate their final confession? Correct. Okay, so it's contamination that you've described confined to the post-admission narrative process. Answer, no. You could have, first of all, pre-existing knowledge. Someone has been to the crime scene or has witnessed to a crime. That's before the interrogation. You can also have contamination through media sources or community gossip, overheard conversations prior to the interrogation, i.e., let's say your family. And then in the interrogation, you can have contamination in the pre-admission portion of the interrogation, even before the suspect says the words, I did it. They're being educated about the crime facts by the interrogators, even if it's not the interrogator's intent or the interrogator's question. That's answer not aware of. Sorry, so he accidentally interrupted him. He said, if it's not the interrogator's intent or the interrogator's not aware of it. Question. That's what I want to focus on. But you're not saying that these are the cases where interrogators, I think it was allegedly, interrogators deliberately contaminated the suspect's confession, are you? Answer, correct. Correct. No, I'm not saying that. Question, okay. Now, if it's not deliberate, how do police contaminate confessions? Answer, well, this is him, by the way. The interrogations are guilt presumption, which means that they presume the guilt of the person they're interrogating, and so they assume the person knows the details. And sometimes in pre-admission interrogation techniques, like the evidence ploy, for example, through accusations, they will tell the suspect details, thinking the suspect knows them, to get more details, or could try to cue the suspect in their attempt to pressure the suspect or persuade the suspect to give a true confession. So they don't realize if they are interrogating an innocent person because they presume that the person to be guilty who has knowledge. They don't always realize that they are feeding the facts, or that they are cueing them to particular answers, or directing them to particular answers. Oh, I wonder what this does. Hold on. It's thinking. Oh, well, it's taking too long. It was this thing called read aloud on the options, but I'm not going to do it. And the same process sometimes happens post-admission, where the focus is not so much on getting the I did it statement, but on getting a story, a narrative with details that and were in their fruitation. They pressure and persuade the suspect and inadvertently direct them or cue them or ask questions that suggest the correct answers. Question, contamination. Can contamination from one interrogation later infect the other interrogations? Answer, yes, because if you're educating the suspect about particular details at one time, and then a time to the person's interrogation and confesses, he or she is likely to know details from time one. The cat's out of the bag. Unless the person didn't hear them or didn't remember them, the contamination from the prior interrogation will carry over to the subsequent interrogation. And you see that in some of the DNA cases. So basically, if you take a kid and you put him in the back of a squad car and you start asking him pretty specific questions about the crime, and then later you go to his school and then you ask him more specific questions about the crime, and then you do it again and again, and by the time March 1st comes around, you probably have a kid who's kind of figured out what kind of questions you're going to be asking and what kind of answers that you want. Right? What kind of story that you want him to tell you. Question. As an expert, when you're looking at the reliability of a confession, how do you know whether contamination exists? So tired of my internet. You guys have no idea. Well, if you have a recording of the interrogation, then your job is much easier because you don't have to rely on anybody's account for that piece of it. You go to the interrogation, you have to carefully go through the statements to see whether or not police are feeding facts, educating the suspect, correcting details, cueing the suspect to the right answer, giving the suspect 50-50 guess options. So that's the one thing you have to do. In a high-profile case that's received media coverage, it would be important to know that it's been reported out there, and whether or not the suspect could have learned that. Does the problem of contamination lead to wrongful convictions? Answer, it does, but I think it's important to say how it leads to wrongful convictions. It's a big part of the story. It's not the whole story. It leads to wrongful convictions because it makes false confessions detailed and look very persuasive so that the tier of fact, the first of all, so that the professor or prosecutor argues that the confession is corroborated by the details and by the quote unquote inside knowledge that's very persuasive. We find in our studies to tiers of facts because the fact of details, and if the prosecutor's argument of inside knowledge is believed, again, appears to corroborate, confirm, drive home the validity and veracy of the confession. Question, and does the problem of the contamination make it more difficult to overturn wrongful convictions? Answer, it is very clear from the DNA studies where Brendan Garrett looked at the history of these cases in appellant and post-conviction, and these arguments were repeated. When error was found, it was harmless error. But perhaps the most disturbing thing about Brendan Garrett's findings, and then Fallon rudely interrupts again with an objection. Attorney Fallon, I'm going to object to the relevance of Mr. Garrett's soon-to-be published law review article and its application to the particular proceedings as whether or not trial counsel were ineffective, which is really the focus here. Court, I understand the objection. This is an expert. He can tell us that he relies on the forming of his opinion. I would appreciate it if you could do that cynically. Oh my god, these big words, dude. Say normal words. Hold on. Let's look this word up. A brief and clear express manner. He could have just said briefly.
Succinctly.
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 Could have just said briefly. See, I don't know if I could be a lawyer because I'd be like, Your Honor, what did you just say? Can you say it? Can you dumb it down? Just like a little bit. The witness. Okay. So this is Dr. Richard Leo. Okay. Even after the DNA established the innocence, trial prosecutors continued to refuse to release individuals who had confessed. Repeated the same arguments. They gave details only the true perpetrator would know. Question. Now, in your experience and your research, is contamination a phenomenon that jurors can typically spot? Hey, Mose. I'm glad that you got your cards today. I'm going to probably be sending you guys more. I'm putting you supporters to work. Trust you that. No, that's the answer. Question, how do you know that? Answer, well, through the studies and research is how we know that. You really have to break it down to see contamination. I think jurors tend to get focused on the confession process itself. Question, okay, and by break it down, you mean show them precisely on the interrogation tapes where contamination occurs? Answer, right, step by step. Question, okay, did you look at the state's Mr. Buckley's 17 corroborating facts in this case? I'm glad that they're going back over this. Answer, I did. Question, and in doing so, were you able to make any assessment of whether or not these facts were the product of any contamination? Answer, yes. Question, what did you find? Answer. I found, as I went through the affidavit for all 17 statements, that all of the statements that Mr. Buckley alleges were corroborating of the confession were unique, non-public knowledge, were not that. They either were fed to Mr. Dassey by the police, or the police cued Mr. Dassey towards the right answer, or they were the public domain, and they have been reported in the media, whether the print or electronic media, newspapers, online. Finally, or there were some statements here which, even though true, were consistent with the explicatory account and in no way incriminating Mr. Dassey. So none of these 17 points revealed unique, non-public knowledge that only the true perpetrator could have known and couldn't have been guessed by chance. Question. Now, you mentioned earlier about the police training with your regard to hold back some details from the general public. Answer. Correct. Question. Do you remember that? Answer. Yes. Question. What are they trained in that regard, Dr. Leo? Answer. To hold back non-public case facts, unique crime details that only the true perpetrator is likely to know, other than the police, unless they are co-defendants and then perpetrators, so that when they confess, if they voluntarily, independently reveal that information, you can argue very persuasively it's evidence of guilt. It corroborates the confession and seals the conviction. So, question. So the less facts that are held back from the general public, the more difficult it is to assess the reliability of a confession. Correct. Okay, I want to show you some clips regarding contamination. Actually, again, since we have a problem with the video, I'm going to read you some clips from February 27th on contamination. I want you to look at Exhibit 315, page 8. Clip 1. While this is loading, I just want to say, I've discussed this before, but this is why I think that there should be some sort of pause or media blackout when crimes are still being when investigated and the suspect has still not been found, because the more information you give out there about a crime, the more likely you have a wrongful conviction. So I believe Jinx was it that asked me, do you think that that one dude of the Idaho 4 will get a fair trial? And I don't think he would be able to, because of all the way the media reports on things. And then you've got the new aspect of the last, I'd say, like 5-10 years of these YouTube people who go on YouTube and, you know, put out all these things that they've seen in the news and even make up stuff just to get those clicks and views. And that also, you know, but things like Nancy Grace and all that, that's why I think Nancy Grace is a real problem, because I think that you shouldn't, I don't think that you should be broadcasting crimes like that. Because one, I mean, I'm a true crime junkie, I'll admit it right off the bat, but I don't mind waiting until the crime or until the person has been prosecuted, and then you could report on that stuff. You know what I mean? So I just think that, one, it shouldn't be a main source of entertainment like that, and then two, I think it jeopardizes the crimes. I think it makes it harder to prosecute the true perpetrator of the crime. And yeah, so that's just my opinion, obviously. And you know, it's also a really risky road, because I don't believe in censoring, just simply because I don't believe, I think it's our constitutional right to be aware of things. But I don't know. I think that there should be some sort of regulation. of some sorts. I don't. It's a very iffy topic because especially when it comes to the government, if you give an inch, she'll take a mile. So if they start to say like, yeah, sure, we can start doing some regulations on making media blackouts during these crimes, but then they'll take it a step further and then start taking away our free speech rights. So that's why I'm like, I don't. It's a very hard. I don't know what the right answer is to this. Other than that, I think maybe these news stations and people within themselves need to take a pause and say, is this really something that we should be reporting on right now? Anyway, back to the scripts here. So they're getting up. You see where I'm referencing? Yes. Question. No, I think that. What page are you on? Exhibit 315, page 1, page 8. Okay, this is Mr. Fassbender speaking. Brendan, we know that Halloween and stuff you were with him and helped him tend to a fire and stuff like that. Behind the garage and stuff. And anything that you saw that night that's been bothering you. Sorry, it's a weird sentence. If you built the fire, and we believe that, that's where Teresa was cooked. Such beautiful language. Okay, what does this clip show you about contamination? Answer, sorry. Well, they're educating him about some of the key facts there. That's where there was a fire. And that's where Teresa's body was, as they say, cooked. Question. That would be in the fire pit. Answer, correct. That was behind the garage. Question. And that they think Brendan built the fire? Answer, yeah. Helped tend the fire, yes. Question. And that Brendan may have seen something in the fire pit? The court. Here, just the witness, correct. The court. Let me just stop this for sake of expediency. I haven't done this before, but oftentimes, Mr. Drizzen, you're actually testifying rather than asking questions. Attorney Drizzen, I'm trying to get through this, Judge, the court, and that's why I haven't said anything about it before. Oh. I agree, Facebook user. Well, that's where the bones were found, but not necessarily cooked either. Right. I agree with that. Attorney Drizzen. Okay, I'll refrain. Court, all right. By Attorney Drizzen. Why is this contamination significant to you? Answer. Well, because then when he repeats back these facts, that's taken by the state to somehow corroborate his confession. But if he first learns of it through the police, then it has no probative value. Probative value. Was it ever clarified that they are Teresa's bones? I'll get to that here in a second. I'm going to highlight this. Okay, let's look at page 8, clip 2, again at the top of the page, beginning with, did you see a hand, a foot? Did you see that? Answer, yes. Okay, this is February 27th. Agent Fassbender says to Brendan, and by the way, I believe this is at the school. So just to give everyone a perspective. Agent Fassbender says to Brendan, did you see a hand, a foot, something in that fire? Clip 3, Agent Wiegert says, that burn pit, Brendan, it was no bigger than this table, okay? You know how big it was. I find it quite difficult to believe that if there was a body in that, Brendan, that you wouldn't have seen something like a hand or a foot, a head, hair, something. Okay, we know you saw something. Clip 5. I find it very hard, Brendan, that you didn't see a skull or a head Why are these clips significant? Answer. Because again, they're educating him about the things that they believe he saw, and he repeats back these facts in his confession. And then the state says this reveals unique non-public knowledge that argued would be false. In fact, he could be repeating back exactly what they told him or suggested, and therefore his confession is contaminated, and these statements have no probative value in establishing corroboration of that confession. Question. Okay, I'm waiting to focus on March 1st, okay? And I want to focus on, I'd like you to focus on clips 1, 2, and 3 on page 8 at the bottom of the page. This is March 1st interrogation at the Manitowoc Police Department. The first clip begins, where did he stab her? You see that? Yes. Okay. Attorney Drizzlin. And then he says, Alex, play the clip. I don't think he clapped. I'm just... Okay, so he plays the clip, and then we see... So this is Brendan in the stomach. And then the person, I think it's Uyghur. What else did he do to her? Did something else. We know that. He tied her up. We know, and then Drizzen says, we know he did so. Oh, no. No, okay. This is back to Uyghur. We know that he did something else to her. What else did he do to her? What else did he do to her? We know something else was done. Tell us. What else did you do? Come on. Something with the head, Brendan. We know you made her do something else. What was it? What was it? We have the evidence, Brendan. We just need you to be honest with us. And then Brendan says that he cut off her hair. And then Drizzen, Alex, I'm going to ask you to continue playing clips on that page through clip 9. And then so then the clip continues. What else? What else was done to her head? Brendan, that he punched her. I actually might have a clip of this on here. What else? What else? He made you do something to her. What didn't he? He would feel better about not being the only person, right? What did he make you do to her? What did he do, Brendan? It's okay. What? And then he says, cut her. Cut her where, Brendan? On her throat. Okay, why don't we stop there for now, okay? Alex, do you want... Okay. Drizzen, the clips that you just viewed, what did they say to you about contamination? Answer. It's my interpretation here is my interpretation here is that he is giving the wrong answers, and they're trying to direct him to the right answers, and that's why they keep pressing him despite everything he's saying. And at one point, I guess, on the clip 3, they suggested that something happened to the head. Okay, question, okay. And that's the first time that there's any reference to these interrogations. That something happened to her head. Is that correct? Answer. That's my recollection. Yes. Question. Okay. And then will you continue playing the clips? This would be, I believe, from where you left off. And then so then it goes into saying, so I believe this is still Uyghur. Extremely, extremely. Tell us this for us to believe you. Come on, Brendan. We know. We just need you to tell us. And then Brendan says, that's all I can remember. And then Uyghur says, all right, I'll come out and ask you, who shot her in the head? And then Brendan says, he did. And then Uyghur says, why didn't you tell us that? And then Brendan said, because I didn't think of it. Okay, again, Dr. Leo, what does this clip suggest to you about contamination? Answer. They're feeding him. They're directing him. The statement that he says he doesn't remember, and they haven't successfully, 5 begins with what happens to her in the head. He's not going to give the right answer. So finally, they just come out and tell him the right answer. Question. And that answer is that she was what? That what? Answer. Who shot her in the head? So read in the context of the earlier clips that you played. He's now guessing wrongly several times. They've hinted at the right answer several times, and they just give up. He says he can't remember. They just give up, and they basically tell him by saying, who shot her in the head? So they're disclosing that she was shot in the head, which she doesn't appear to know. Question. Now, Agent Wiegert later asked Brendan in the clip, I believe, 11, what do you know what side of the head? Do you recall that on page 9? And then the answer is yes. It's marked as clip 6. All right, that followed. Is this question? Is this an example of contamination? Answer, yes. Let me look something real quick. I might have a clip that has that scene in it, not from Wiegert, or not from, let me see something. Nope, nope, nope. Is this it?
The third paragraph. Brendan needs to be alone when he sees.
Nope, that wasn't it. I probably don't have it anymore here. Let me see, because I know I have a clip. Oh. I know I have a clip somewhere of that particular scene, and I believe it was Jerome Buting who was talking about it. Now, to answer this question, was it ever clarified that they were Teresa's bones? Not 100%. Teresa, there's like a certain amount of DNA markers that you need to say yes, 100% that is this person. And I think, I can't remember the exact numbers, but I'm just going to say I think it was 13 markers that mean that it's a direct you, and those bones only met like 8 or 9. So scientifically speaking, or even legally speaking, I don't think you're allowed to say that those bones were Teresa's because they didn't match a certain amount of markers. So that's why a lot of people in this believe that Teresa may not have been killed. Like, there are a group of people who believe that Teresa is still alive out there somewhere. I don't personally believe that. I think that she is dead. I just don't think that those bones that they found were hers. I think that, unfortunately, she might still be out there. And that those bones were a decoy from another thing. Because you have no photographs of the bones in the actual pit. You have no, like even, what was it, last Monday when we were reading the book? And they were saying, the news media was reporting that there was smoldering bones in the fire pit with like fingers sticking out of the pile. That wasn't, if that actually was, that they would have took pictures of that for the crime scene, and we would be seeing them. Obviously, the only pictures we have of these bones are spread out on a table, you know, and even the guy who did the dental records, the bones were so destroyed that he had to glue them together. And even then, it was like, you know, so I personally think that they found, unfortunately, I think there was another crime that was committed around the same time. They found the remains of that crime, and they smashed up the bones, and then they called it good and said it was Teresa's. I think that Teresa's, unfortunately, is deceased, and she's still out there somewhere. And just like Facebook user said, I think she would have come forward by now if she was alive, or somebody would have at this point, because the case is highly publicized. And somebody, I mean, people, I honestly think she would have came forward, or somebody would have came forward and said, no, Teresa's still alive. I don't think that she's still alive. That's just my opinion. And I'm not saying that anybody out there who disagrees with me, who thinks that she's still alive, is wrong. And, well, because unfortunately, anything if you guys have seen, if you've been following this for a while, anything in this is possible, and everything in this is absolutely insane and crazy. So it wouldn't, like, honestly, if Teresa Hallback was still alive and she did come forward, I don't think I would be that shocked. But I do, like I said, my personal belief is that she's gone from this world. So unfortunately, but yeah, the bones, in my opinion, I don't think those bones were hers. I think those were decoys' bones. And that's why, to me, it's crazy that they say there's so much evidence that Brendan committed this crime or helped commit this crime. There's no body. There's no murder weapon. There's no scene of the crime. Even there's no scene of the crime. There's nothing. All there were words. And it's crazy to me that in America you can be convicted of a crime for life based on words and words alone. So, let me see. Also, I was too busy talking. No, that was just a news report I found. How many lawyers? Yeah, that one. Let's see. Here we go. Is this it? No, that's not it. It's probably still on TikTok. I may not have downloaded it. Oh well. I'll have to find the video and maybe I'll post it in the group. Because there is a video. That I have. Yeah. Yeah. Is this it? Nope. Oh well. I'll find it later. But anyway, back to reading this. So question, yes. Answer, how so? Wait, what was the question again? Okay, question. Is this an example of contamination? As far as the, do you remember which side of the head she was shot on? It was what the original question was. Answer. They are affirming the answer. Like the other ones, excuse me, they keep pressing him to go on. They accept this answer, and then they imply that was one or the other side. Then ask him. Question. Okay. And so why is he telling him that she was shot in the side of the head? Contamination. Answer. Well, it's also the location of the head as well that they are suggesting. Question. Okay. Now, in his arguments to the jury, the prosecution placed great weight on the fact that Brendan was able to say, and she was shot, and that she was shot in the head, and that she was shot in the side of the head. In your opinion, after reviewing these clips, what do you think these facts are corroborated? Answer, no, because they come from the interrogator, as these clips show, not from Brendan. So they did not come from Brendan. They have no probative value in corroborating the confession. He didn't independently volunteer them. In fact, exactly opposite. He doesn't appear to know where they came from and guessed incorrectly. Ginger, you're lost. Came from guessing correctly, despite their initial cues, until they initially feed it to him. Attorney Dresden. Alex, I'd like you to play clip 21. Blah, 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 blah. Where Mr. Fassbender says, tell me where in the head. I think it's page 12. Page 12. Well, there's only 15. Clip 15, but okay. On Alex, do you have it, Alex? And then here we go. Tell me where in the head. What sides? And then I think Brendan answers to the left side, I think it was. Attorney Drizzen. Dr. Leo, does this fact that Brendan say that she was shot in the left side of the head carry any significance? It's a 50-50 answer, right? To me, no. This is an example of one of those facts that could be guessed by chance. Yeah, see? There's only two sides, 50-50 likelihood of guessing it. So it has no probative value in terms of corroborating the confession, since it's easily can be guessed by chance, and therefore we don't know whether he provided that independently or whether he just guessed. And of course, since he was directed and he couldn't get the answer right in the first place, there's multiple reasons why this is not corroborative. Okay. I want you to focus your attention now on page 9 again. I want to show you some clips relating to where Teresa was shot. Brendan talks about that. We'll begin with what is listed as exhibit number 315 as clip number 7. Then he asks Alex to play the clip again. And then Alex says something. And then he says, I'm sorry, Alex. What did Alex say? Okay, so here it goes. And we know some things. What are you doing? Oh, hi, Dieter. You can lay down. Go on. That you are not telling us. We need to get the accuracy about the garage and stuff like that, and the car. Again, we know, hold on. Sorry, I sneezed real quick. We need to get the accuracy about the garage and stuff like that in the car. Again, we know that something's happened in the garage and in that car. We know that. You need to tell us about that so we know you're telling us the truth. Attorney Dresden, okay. Would you keep playing? That's marked on your exhibit as clip 9. And then took her to the garage, again with 10. Tell her where she was shot. And then Brendan says in the head. No, I mean where? In the garage, outside, in the house? In the garage. Okay, was she on the garage floor or was she in the truck? And then Brendan says the truck. And then we know that's not correct, according to the detectives, because then he says, come on, where was she shot? Be honest here. The truth. In the garage. That's what Brendan responds. Okay, let's stop here. Question. Dr. Leo, the fact that Teresa was shot in the garage was argued to the jury as corroborated fact. In your opinion, is that a corroborated fact? Answer. Well, again, they're directing him to the crime took place and repeatedly telling them the garage and the car. Question. And in fact? Answer. And in fact, they say, tell us where she was shot. And he says in the head. And then Fassbender says, this is clip 10, no? No, I mean, where in the garage? So in effect, they're telling him. Now, after Brendan's interrogation, Dr. Leo, you're aware that the police went into the garage and they actually found some evidence that she had been shot there, correct? Question. Answer, yes. Question. Isn't that an example of the most valuable kind of corroboration, evidence of which the police did not know about prior to the confession? Answer, correct. Question. But what is the significance of this evidence in light of the tape that you just reviewed? And Facebook user Yeah, he did originally say it. He actually, first he said garage, and then he said by the fire pit. And then he went back to the garage. So I believe he first said garage, and then I think in a later interview after March 1st, when he was already incarcerated, then he stated in that interview that it was by the fire pit. And then the detectives were getting upset with him, and they were like, no, that's not where, So this woman, this poor woman, if any of the story was correct, had the most horrific amount of injuries and did not die. And I don't mean to laugh and like, haha, like that's funny. But like her throat was cut. That didn't kill her. She was shot like 10 times, and that didn't kill her. She was stabbed, or was it that she was stabbed in the stomach like 10 or 11 times, and that didn't kill her, and then they shot her. That poor woman, if any of that was true, it also seems very hard to believe, that somebody didn't die from the first initial injury, which was the throat cutting. But that's just how crazy of a story this is. And the fact that a jury sat there and listened to the interrogation in its full through and didn't question any of these details is just absolutely crazy to me. But they only showed the March 1st, too. I just want to note. They didn't show, I don't believe they showed any other interrogation. So they didn't show any other interrogation other than the March 1st one. So if you think about it, I guess they should have showed all of them. Don't you think? Like, they should have showed all of them and then had the jury, like, look at it. And maybe the jury would have seen, like, oh, shit. This kid has no idea what he's talking about. But then again, I don't know. A lot of us only first saw the March 1st interrogation and we all knew something was wrong. So I don't know. Obviously, a lot of people, also I should say, a lot of people, there's a thing out there where people are saying that the jury was tainted and that the sheriff at the time bought the jury pizza and would sit with them during lunch and all that kind of stuff. And so a lot of people feel that the jury pool was manipulated anyway to convict this kid. Brendan had no chances. I don't know how any of that. And he still cannot, like, he can't get a retrial. Like, he can't use this particular thing to get a retrial again because he already tried and it didn't work. Hey, Darkside. It loses all probative value as means of corroborating the confession, establishing its reliability, and then when the police educate the suspect about the fact, and then the suspect repeats back the fact, and then they discover something new related to the fact. So it violates their training, and it makes it more difficult to establish the reliability of the statement they elicited because it is corroborative value is completely undermined by the police, unnecessarily providing him that information in their interrogation. Question. Okay, now, Dr. Leo, I want to focus your attention on page 10 of this exhibit. What's marked on your exhibit as 13, beginning with the words, okay, what else did he do? Do you see yes? Where that is, yes. Alex, can you play the tape? And then he plays the tape. Okay, what else did he do? Did he... Did he something else? You need to tell us what he did. After the car is parked there, extremely important, before you guys moved that car. And then this is, oh, I didn't really... Brendan says that he left the gun in the car. And then they say, that's not what I'm thinking about. You did something to that car, to the plates. I believe you did something else to that car, Brendan. I don't know. Okay. Did he go and look at the engine? Did he raise the hood at all or anything like that? Did do something to that car? Brendan, yeah. What was that? What did he do, Brendan? It's okay. What did he do? What did he do under the hood if that's what he did? Brendan, I don't know what he did, but I know he, and then it's throws off. Question. Dr. Leo, in light of these questions, what value ought to be placed on the fact that Brendan say that he saw Stephen go under the hood of the car? Again, answer. Again, I don't think there's a probative value because Fassbender says prior to Brendan saying that in the middle of this, did he Yes, exactly. It sounds like listening to a fortune teller. I'm getting, and then you say something very vague, and then you see if it piques the person's interest, and then then you embellish on that. Yes, that's exactly how a fortune teller is what they're doing with Brendan now. Did he raise the hood at all or anything like that? And then all Brendan can say is he doesn't know. At the end of the clip, but he knows that Stephen Avery went under. So this is a classic example of just feeding back a detail that was first suggested by the interrogators, and therefore it's not inside knowledge. It has no probative value. It does not corroborate the confession. Question. But this fact, again, led the police to discover Stephen's DNA on the hood latch of the car. Doesn't that provide precisely that kind of corroboration you want a confession to provide? Answer. Yes. Maybe a different way of answering the prior question. And this question would be to say that this would have been something very valuable to hold back. That they had held back, had they held back and had he then independently supplied it, this would have been very probative. If that had happened, and it would have been corroboration. If he could not have provided it, it would have suggested the opposite. And here, it doesn't appear that he could provide it until he was told. Question. I want to show you more series of clips, okay? This is a little bit longer, so... And then refresh. This is going to be at the bottom of page 10. Alex, can you bring it back if possible? It's going to be the bottom of page 10. Did you play? Okay. Did you place some things in that burn barrel that night? What the detectives ask. Brendan says no. What happened to Teresa's other personal effects? I mean, a woman usually has a purse, right? Tell us what happened to that. Brendan says, I don't know. What happened to her cell phone? Don't try to just think of something. Just, Brendan, I don't know. Stephen, did you see whether a cell phone of hers? Brendan, no. Do you know whether she had a camera? Brendan says no. Stephen, tell you what he did with those things. Brendan says no. Did you tell us the truth? Brendan says yes. What did he do with her possessions? Brendan says, I don't know. Brendan, it's okay to tell us, okay? It's really important that you continue being honest with us. Don't start lying now. If you know what happened to the cell phone or a camera or her purse, you need to tell us, okay? The hard part's over. You know what happened to those items. And then Brendan says, because when I passed it, there was like a purse in there and stuff. When you passed what? Brendan, the burn barrel. Did you look inside? Why did you look inside? Brendan, because it was full. What else was in there? Brendan, like garbage bags and Did you put those things in the burn barrel? Brendan says no. Nosy! Did you actually see those things in the burn barrel? Brendan says yeah. Tell me, what did you see in there exactly? Like they were buried beneath the garbage bag that was. How do you know? How could you see it if they're underneath the garbage bag? Because the garbage was like on top of it, on the top. Okay, so we have the barrel, okay. You got the barrel, okay. Here's the top of the barrel, and the garbage bag is at the top. Brendan says, yeah. Where were those items you said you saw? Like underneath it. Underneath the bag? How would you see that? Well, if the bag's like far off the top of the thing, you could see underneath there. What did you see? And then he says, like a cell phone, a camera, purse. Question by Attorney Drizzen. Beginning of the question, did you put some of those things in the burn barrel that night? Where Brendan shook his head no. And following through the clip, you just saw, this is an example of contamination? Answer, yes. Yes, because again, they're educating him on what was in the burn barrel. What they believe was in the burn barrel. The purse, the cell phone, the camera. And when he says at the end of the quote, cell phone, purse, or camera and purse, the very bottom of 14. So again, that has no productive value because they gave him that fact before he gave it back to them. So it couldn't be said that he independently volunteered those unique non-public facts. This is a classic example of contamination. Question. Okay. And then the only way to see this contamination is by doing what, Dr. Leo? Answer. Well, you have to break it down. I mean, contamination is a complicated case, or a case with a lot of facts. You've got to break down the record. You've got to go through, phrase out the recorded interrogation. You also have to do some investigation, of other sources of contamination if they exist. Question. Dr. Leo, I want to talk to you about what Joseph Buckley in his report refers to as resistance. Question. Okay. Or answer. Okay. Question. Do you know what I'm referring to? Answer. I believe so, yes. Question. Okay. Mr. Buckley's report, he cited a number of facts that Brendan supposedly resisted. Do you place any weight on this so-called resistance? Answer, no. Some of the things that Mr. Buckley is calling resistance, I think shouldn't be called resistance. They don't imply active resistance. He's just not adopting them. But more generally, in false confession cases, where there may be or is a lot of contamination and suggestion, you don't see the person mechanically adapts or repeats back every single fact that they suggested to them as if they were an automation or simply a sponge. So you're also going to get some suggestion or statements back that are not feedback to the suspects. So no, I don't put weight on that. The most important thing is to do, again, is post-admission narrative analysis, an analysis of contamination. Question. And some examples of resistance cited by Mr. Buckley include examples where Brendan denies doing things but says that Stephen did them. Answer, correct. Question. Do you recall that? Answer, yes. Question. What's the significance of that? Answer. I'm not sure why you would call that resistance or why you would say that somehow corroborates his confession since they're encouraging him to blame. It's in the fitting with the theme of the interrogation, a part of it. They were interrogating him. Oh, it didn't do it. They were, it looks like encouraging, not interrogating. Hold on. Encouraging him to shift the blame onto Stephen. That was part of their strategy. In particular, their inducements and communicate he was less at fault or he wouldn't get punished as we described earlier. Question. Now, Dr. Leo, you attended the retraining, correct? Answer, correct. Question. You've read the criminal interrogations and confessions. Answer. Every edition of it going back to 1942, yes. That's a lot of reading. Okay, do the retraining materials lack the contamination? Talk about it. Wait, okay, let me rephrase that. Let me say that again, actually. Does the retraining materials talk about contamination? That's what. Answer, yes, they do. Fallon, I'm going to object. There's no relevance about the retraining materials. Court, where are we going? Home after this. Where are you going, Judge? Drizzen. Mr. Buckley in his report states that Agents Wiegert and Fassbender were in their questioning and Brendan's interrogations were following standards of accepted practice in the interrogation of Brendan Dassey. I believe Dr. Leo can say that they weren't even following Mr. Buckley's standards of accepted practice. Court. I don't think that report's been offered to evidence at this stage, has it? Drizzen. It hasn't, but I mean, he's reviewed it. He's relied upon it in his opinion. It's not going to be offered into evidence. It's going to be offered into evidence. The court. Well, until it is, the objection sustained. Drizzen. Can I make an offer of proof at this one point, Your Honor? Court. Narrative offered of proof. Drizzen. Dr. Leo, if allowed to testify, would testify that this is his opinion that investigators, Wiegert and Fassbender, in their extensive use of contamination in this case, did not allow standards of accepted practices in the interrogation of Brendan Dassey. Attorney Fallon, there's been no testimony that they've employed this technique, nor has there any testimony at trial from Mr. Buckley. The court. Well, he's made the offer of proof, so that's on record. Go on. Drizzen. Dr. Leo, there was a confession expert called as a witness in this case. Are you aware of that? Are you talking about Dr. Gordon? I'm sorry. Yes, Dr. Gordon. He is. What kind of expert would you call Dr. Gordon? Answer. Dr. Gordon is not a confession expert. Dr. Gordon is a clinical psychologist. He may be an expert on personality factors that are associated with somebody being more vulnerable to giving or making a confession, though I'm not sure of that. Question. Have you worked on cases where there have been suggestibility experts? Answer, yes. Question. And so there's a division of labor between the two of you in these cases? Answer, correct. Question. Does that does the suggestibility expert focus on? What does the suggestibility expert focuses on, and what do you focus on? Answer. Suggestibility experts focus on the factors related to a suspect's personality and may predispose them to be more vulnerable or susceptible to suggestion and influence in interrogation techniques, and therefore more likely to agree with, repeat back, or make a false confession. Sally sells seashells by the seashore. An expert like me, a social psychologist who knows about police interrogation techniques and false confessions, will testify about the psychology of interrogation, coercion, and how the literature on false confessions, and why those techniques can lead to a false confessions, and issues about pre and post admission interrogation, including contamination and reliability. Question: do you believe that suggestibility expert alone can adequately educate a jury about the reliability, how to assess the reliability of a confession? And then Fallon objection for speculation on this witness as the capabilities of another expert, and blah blah blah. Court, I'm going to overrule the objection. He can give his opinion. Thank you, Your Honor. Dr. Leo, not unless the suggestibility expert is also an expert on psychology of interrogation and the phenomenon of false confessions. Question: and are you aware that Dr. Gordon, in this case, specifically said he was not an expert in those areas? Answer: yes. Question: okay, now do you believe that the topics about which you talked today, psychologically, coercion, and contamination, can be effectively demonstrated through cross-examination alone? Answer: you're talking about cross-examination of whom? Question: of investigating officers. Thank you. Answer: no. Why not? Because the social science research of these topics are not areas that investigators are familiar with typically. They don't read the research. They're not familiar with it. They may have experts in their particular training on how to use particular techniques. So to educate the jury about these counterintuitive and not popularly known phenomenon and their effects and why they're significant in understanding how false confessions come about is not something the average police interrogator is going to know about. Question: and there evidence or research that suggests that juries need to be educated about these topics? Answer: there's evidence suggesting that juries are not aware of this. These counterintuitive phenomenon, they're not aware of the main findings in the research literature on interrogation, the psychology of interrogation, coercion, and that in addition to their lack of knowledge, that they are strongly influenced by confession evidence, that they tend to assume if someone confesses, it's a true confession because they don't understand why somebody would falsely confess. They don't believe that they would falsely confess, and so they are highly skeptical of any claim of false confession. Question: I just want to, one final question, Dr. Leo. Are you saying that in every confession case, every unreliable confession case, that an interrogation expert like yourself must be called? I think they should. That's just my opinion. Let's see what the answer. Answer: no. I mean, there are many cases where attorneys may argue it's unreliable confession case, even if the indicia of reliability. What I'm saying is that in a case like this, where as we've seen, there's no evidence of coercion inducements. There's evidence of contamination. There's other risk factors associated with false confession. Low IQ, youthful, suspect. In a case like this, a false confession expert, police interrogation expert, can be uniquely helpful to the jury. Drizzen: 1 minute, Your Honor. Okay. Dr. Leo, as part of your opinion today, did you review extensive newspaper articles and printed out transcripts of television news coverage? Answer: yes. Okay. When you reviewed those, what did you find? Answer: that many of these facts that Mr. Buckley lists in his report that were corroborating Brendan Dassey's confession, that they were allegedly revealed unique or non-public details not likely guessed by chance, were in fact reported in the print and electronic media. Question. Okay. And reported prior to his confession. Question. Can you take a look at Exhibit 312? Summary. Also look blah, blah, blah. And does this exhibit reflect the universe of media coverage that you reviewed in connection with rendering your opinion? Answer, yes. Okay. At this time, Your Honor, we'd like to ask for a number of exhibits to move into evidence. All right, and then he says, give me the numbers you're moving. Number 212, which is a video exhibit with the clips that we've showed Dr. Leo. 212 clips that I was showing. Which are universal media exhibits that Dr. Leo reviewed prior to rendering his opinion. The group of exhibit, a whole bunch of, we're underlining documents which he based his opinion, which would be Exhibit 69. February, which is the transcript of February 27th interview. Audio CD of that interview. Video of Two Rivers interrogation. Transcript of that. I believe those are all the documents we seek admission at this time. 315 has been previously received. I have a question about one, but where we'll get to that. Mr. Fallon. Yes, I have several questions. I think 315 was previously admitted to the extent that was discussed with Mr. Kaczynski, I think. Correct. All right. Let me go into reverse order because it's easier. 210. Which I suspect added additional. So they're going over the evidence that Drizzen is admitting into court. That's what they're doing right now. So, which makes up transcript part we talked about. Vehicles with them. I have no objection to that, but there are other factors contained in both the video and 315 that we still have standing objection to. I do have, however, objections to 312, 313, 314, and 87. With respect to 312 and 314, and again 87, they haven't been conditionally tied up in this particular case. And right now there's still a question of the relevance and materiality as it relates to these issues. And then the court says, yeah, my question was to those as well. You had Dr. Leo testify very briefly from 87 as in effect the chart replicates or supplements his actual, replicates some of his testimony, but nobody has testified to the preparation of exhibits. Are you intending to call a witness to do that? Those exhibits in particular, this is essentially just a demonstrative exhibit. Okay, Your Honor. Well, it's more than a demonstrative exhibit. I just took a close look at 87. It states there's several additional opinions which are to offer here. For instance, column 2, did the state's physical evidence actually corroborate this detail? Well, one, that's a question as whether it's an appropriate question for this particular witness in the context which is being offered. So does it contain additional opinion evidence? That's interesting. I'm learning a lot today on court proceedings, in which has been discussed, some of which is questionable admissibility. So, but that's not the primary objective. The primary objective is still tied into this particular case. Then Drizzen says, well, I believe it was tied into this particular case, but I will accept that at least this particular column is probably, requires knowledge that Dr. Leo may not be best witness to. In any case, it has been validated by whomever prepared the exhibit. Okay. And with respects to Exhibit 312 and 314, you object to those, did you? And then Fallon says he sent that. Just say again, the impact of the media coverage in this case is yet to be established. Drizzen says, Judge, the point that we use Dr. Leo for, and I think we can hopefully agree to admit that these documents for this limited purpose at this time, is that these were facts that were in the public domain. And I don't think there's any disputing that. We didn't, and then Fallon says, we didn't dispute that. They clearly were in the public domain. But the fact that they were in the public domain, importance and signifies has yet to be established. The court. Well, Dr. Leo has testified that the fact that they were in the public domain, in his opinion, meant that the defendant could have access to them. I don't see the exhibit as going one way or another on that. It's simply if the state is acknowledging that these were facts in the public domain, that's what I'm going to receive the exhibits for. Fallon. Well, for that limited purpose, then I'm not going to object. The court. All right. Objection or exhibits 312 through 314 are reserved for that purpose. Those portions were testified here today. With respect to 212 will be received. 315, the additional portions were testified here today will be received. 87, the court will withhold ruling. It's interesting. I guess if it's not an exhibit in the court, then they can't testify against it or on it, right? They can't bring it up. So it has to be in evidence. As for the remainder of the exhibits, I will believe exhibit blah, blah, blah. They're from received. Tristan. Judge, there's just one more exhibit. That would be Dr. Leo's affidavit, which is exhibit 3. Fallon. I would object to that. Court, yeah, I'm not going to admit that. He's testified here today. Tristan, okay. That trumps the affidavit. Thank you. Court, any further? No questions. Your final one question was about 15 minutes ago, so there's a lot of exhibits in this case. The court, all right, Mr. Fallon. Mr. Fallon. Attorney Fallon, yes. Could I have just about 5 minutes to put my stuff for the cross here? Ooh, now we're getting the cross-examination. Let's see. So this is about 120 or 291 pages long. And so far we're on page 249. I've been live for almost 2 hours now. I feel like I'm just going to keep pushing through until I'm done with this because it goes by really fast for me. I appreciate all 5 of you for being here that are still listening on. But I'm just going to keep going because I have nowhere else to go today. This is it, guys. So we'll finish. I feel like we'll finish the Richard Leo post-conviction hearing. 6, I'm still here. Yay! You're still here. So I am going to take a little breather, though, for a quick minute. Does anybody have any questions? Well, I'm going to stretch a little bit. Any questions at all of what I've gone over? I hope everybody's kind of learning something from this, or at least learning the process of how these post-convictions hearings go, and taking something from it, you know. Let's see if I can actually... Is Megan still here? I know she was on Facebook. Is that who's talking to me? Is Megan? I'm going to take a Tylenol. Okay. Excuse me. My nose is also really stuffy today. I don't know why. Other than I think it's just that time of year. Let's see. Yeah, Megan is still here. That is Megan. Megan, I sent you something in the mail, so you should be getting it soon. Okay. Let's go. We can do this, y'all. Okay. We'll recess for 5 minutes. Before we do that, how long do you envision this as taking? And then he says, I won't be done in an hour. I can assure you that. The court, okay, that's good. But can you give me any estimate? Hopefully mid-morning tomorrow. Okay. So they went on recess. It's at 3:40 or 3:35 p.m. and now it's 3:42 p.m. Cross-examination by Attorney Fallon. So question, good morning, doctor, or good afternoon, doctor. And then he says, good afternoon. Question, I just want to be clear, what exactly are you? Are you an attorney, a JD? Or are you a social psychologist? How do you see yourself? That's a loaded question. How do you see yourself? I'm a Pokemon master. I'm a social psychologist and a criminologist by training. I also have a law degree. I am a professor of law, but I have never taken a bar exam or practiced law, so I don't consider myself an attorney. And if somebody did, I would be a non-practicing attorney. Question. So when you emphasis is more of a social psychologist, criminologist, and he says correct, as a social scientist. Ooh, social scientist. Question. As a social scientist, okay, so in terms of the codes of responsibility or behavior, you would find yourself required, for instance, to follow the code of the American Psychological Association. Answer correct. For instance, for the California Psychologists Association. Answer, I don't belong to that organization. Question, you don't? Okay, all right. Well, now there's a difference between social psychologist and a criminal psychologist. Answer, correct. Question, in your understanding, tell us what the difference is. Answer, well, a clinical psychologist is somebody who studies personality factors. He just went over this like a few pages ago. But here we go again. A clinical psychologist is typically a practicing psychologist that would be a licensed psychologist. A social psychologists are typically academic psychologists. They don't do therapy, they don't practice, they're not required to get licenses, and their subject matter is different. As I described on direct, what a social psychologist study. Question, all right. And so in this particular case, then, you don't have any other experience in medicine as a clinical psychologist, and you don't consult with clinical psychologists to assist in your work. Answer, well, I'm not a clinical psychologist or a clinical psychiatrist. I don't typically consult with psychologists or psychiatrists, but there are cases that I've worked on where there will be a psychologist and occasionally a psychiatrist. The two different things on mental health. Usually a suggestibility expert, and I do rely on their opinions sometimes. Question, but those aren't your opinions that you normally form yourself. Answer, correct. Question, okay. And although you've watched many interrogations, in fact, I think your original dissertation was that on Inside the Interrogation Room. Answer. That's an article that was published from the interrogation. Question, right. From the dissertation. Question, right. And that's where you're studying the Oakland Police Department. Correct. And 182 confessions observed. Interrogations. Yeah. All right. And so although you've studied them and been allowed to monitor them, you never actually conducted interrogation yourself. Answer. Correct. Question. Is that something that a criminologist would do? Answer. No. Question. In your view, they wouldn't, their role would be limited observing, monitoring, critiquing interrogations. Answer. Well, I wouldn't put it that, but maybe we could agree on studying, analyzing, researching, publishing about. There may be some academic interrogation expert who, prior to starting, were cops, but most were not. Question. All right. Now, from your curriculum vitae, you are now currently a professor of law. Is that your sole responsibilities? Answer. Correct. Question. All right. So as we say, that would be your day job. Answer. Correct. Question. All right. And prior to that, you did what kind of work? Answer. Prior to that, I was a professor of criminology and a professor of psychology at UC Irvine. Prior to that, I was a professor of psychology and an adjunction professor of law at University of Colorado Boulder. Question. Okay, now this particular case, I want to go over some of the things that I believe you reviewed in preparation for your testimony, all right? Now, as I understand it, you reviewed the materials, and by what I mean the transcripts and DVDs regarding the February 27th, 2006 statement at the Two Rivers Police Department, correct? And he says, yes. Oh, I have to refresh again. Yes. Question. And I believe you indicated and gave us your thoughts that you also listened to the audio interview and reviewed the transcript of the interview, which occurred at Mishicot High School, preceding the Two Rivers questioning. Answer. Correct. Okay. You likewise reviewed the transcripts and DVDs surrounding the March 1st, 2006 statement. Answer. Correct. Question. And you reviewed the transcripts and DVDs surrounding the May 13th statement. Answer. Correct. Did you review any other materials or statements made by Mr. Dassey that assisted you in rendering your opinions that you've rendered today? Answer. Well, Mr. O'Kelly's polygraph interrogations, May 12th, that were mentioned earlier. Question. Anything else? Answer. Not that I recall. Question. All right. I see also, interesting enough, you reviewed a file by attorneys Buting Strang in preparation for the sentencing of the Stephen Avery case. Is that correct? Answer. Are you referring to my affidavit? Question. Yes, I'm referring to your affidavit. Answer. Yes. Question. I believe it would be 1, 2, 3. I think that's the 4th bullet point. I thought they couldn't. Wait. Can Fallon bring up the affidavit, but they weren't allowed to submit it into evidence? So how can he bring up the affidavit that Dr. Richard Leo did if they're not allowed to submit the affidavit into evidence? Because he just said we don't need to do the affidavit. We don't need to submit it into evidence. What's going on? Did I just catch something? Like, I'm not an expert, but I thought he was only allowed to refer to things that were submitted into evidence. But correct, on page 2. Page 2, right? Correct. Why did you review that? Answer. Because it was provided to me. Question. I'll come back to that point in a minute. Did you review any of the police reports or audio clips regarding Mr. Dassey's questioning by attorneys in Marinette County on Sunday, November 6th, or later that week, November 10th, 2005? I don't believe so. Question. Were you aware that he gave statements to law enforcement those days? Were you not? Answer, yes. Now, looks like I reviewed some reports from the Wisconsin Division of Criminal Investigation or Department of Justice. Dated November of 2005, as well as the Marinette County Sheriff's Department. So some reports, yes. So you may have seen the reports. Do you remember seeing if there's any transcripts associated with those reports, or did you just review the police reports? Answer. I believe I just reviewed the police reports. Question. All right. And the authors, if I were to throw the names of the officers involved in the questioning period, would you recognize their names so that you and I could be sure you looked at what I think you're looking at? Answer, no. I'd have to look at the materials that I looked at. Question, all right. We may very well come to that. I believe also you indicated in your affidavit that you reviewed Calumet County Sheriff's reports associated with the February 27th, I take it, February 27th interview with Mr. Dassey, or were those interviews or investigative reports regarding other subjects matter? Answer, I believe they related to Mr. Dassey. Answer, all right. I see also you reviewed the final report of Dr. Lawrence White dated May 11th. Answer, correct. Question, and that's because it was provided to you along with the defense attorney's filing in the co-defendant's case, Stephen Avery, correct? Yes. All right. You also received and reviewed a report of Mr. Buckley's, correct? Answer, yes. Question. All right. In this particular case, you reviewed the transcripts, correct? And those were trial transcripts. Well, that's what it was. If that's what it says on my affidavit, so that's what I believe I did review. Question. Did you review any transcripts from the motion hearing admit the testimony of Dr. Gordon? Answer, not that I recall. Question. Did you review the suppression hearing transcripts? Answer, not that I recall. Question. Any particular reason why? Answer, I reviewed the materials that were provided to me. I think he's trying to say that he either reviewed too much or he didn't review enough to make a professional opinion. I think that's what Fallon is basically trying to bat around to. Is that either he reviewed too much that wasn't on the record, or he didn't review enough to make a professional opinion. That's what I feel like he's trying to get at with these questionings. Did you ask for any additional materials? No. So you're relying entirely on what the defense counsel figured you need to render the opinions you rendered. Answer, correct. Question. And is there any question in your mind if you would ask any additional information, it would have been provided? Answer. I assume it would have been, yeah. Question. You also reviewed an investigator Sorolinski's report from November 13th, 2005. Answer. Yeah, this is the Wisconsin Department of Justice. Question. Yes, the Division of Criminal Investigation report, investigator Sorolinski. Answer, correct. Again, I don't recall seeing any transcript that may or may not have been associated with that report. Answer, I'd have to review the report, correct. Question. Now, also in your affidavit, primarily beginning on the page 3, you listed reviewing 11 different media reports on this case, correct. But yet in the affidavit we just talked about, and media summaries, the number escapes me at the moment, but there are significantly more media reports that you've listed here. Answer, yeah, additional materials that recently provided to me. Question, and affidavit was prepared after the, okay. And question, after the affidavit prepared, what additional materials have you reviewed after you prepared this affidavit, which is dated, looks like March 5th, 2009? Additional newspaper stories, the DVDs, transcripts of Mr. O'Kelly's May 12th interrogation of Brendan Dassey, Mr. Gordon's report. When did you review those? Answer. I reviewed Dr. Gordon's report last night. I reviewed the media stories, the DVD interrogation tapes, transcripts of O'Kelly's interrogation. I believe either towards the end of last month or the beginning of this month. Question. All right. So that would be, just so the record is clear, that would have been December of 2009 or early January 2010. Answer correct. Okay, nothing. Anything else that you answer? Not that I recall, no. Question, okay. So let me be clear. Then you examined no other materials or investigative reports related to the prosecution of Brendan Dassey and those which we just discussed. Oh, I'm sorry, Mose. I feel you, though. Answer. Yes, unless it's not recalling something. Unless I'm not recalling something, but I believe I'm recalling everything. Question, and by that primarily I'm asking you, you didn't review any of the investigative reports prepared by the officers. Answer, other than those that are listed here, correct. Right, yeah, okay, yeah. Question, so are you aware that there was a substantial investigation in this particular case because of the co-defendant, Mr. Avery? Answer, correct. Question, and you were aware in this particular case that initially the police believed that they had refresh. Quote, gotten their man, close quote, with the arrest of Stephen Avery in November 2005, right? Answer, correct. Question, all right. So there wasn't a lot of media attention directed in this case, with the focus on being on Stephen Avery literally from November through January in February of 2006, right? Answer, yes. Question. In fact, all the media reports that you reviewed in focus was almost exclusively, if not exclusively, on Stephen Avery. Answer, correct. Yet with the respect of those media reports, you made no determination as to their accuracy. Correct? Answer, correct. All right. And that's because you didn't review any of the investigative reports regarding Mr. Stephen Avery, correct? Answer, no. It's because I wasn't asked to make a determination of their accuracy. Question. You were not asked to make a determination about their accuracy. Why not? Answer. Well, you have to ask counsel that. Question. All right. Their accuracy would have no bearing on whether or not the contamination was real or imagined. Answer. Well, if they were, no. No, I don't. Yeah. I don't think it would. If the information is out there, then it's still contamination even if it's inaccurate information. Question. Even if it's inaccurate? Answer. Correct. Question. Well, come back to that. May not get to it today, but all right. You reviewed no school records of Brendan Dassey, such as behavioral records, individual education plans, academic performance records. You reviewed none of that information, correct? Answer, correct. And I just want to step in and say the reason why is because he already explained it. He's not a psychologist, a behavioral psychologist. He's a criminal he does criminal psychology. That's his profession. He's not here to say whether Brendan's low IQ or blah 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 has any. It's all about how the interrogators were using the confession. So I don't know where Fallon's going with this, but you did not review any statements on reports of Miss Susan Brandit. Answer. Correct. Not that I recall. And question. All right. Did you review any materials or information regarding a woman by the name of Chris? Oh, I'm not even going to try that. Schnogenberger. Gross. That's her name. Answer. Not that I recall. Question. I'm going to assume, and please correct me if I'm wrong, but I believe you've never interviewed Brendan Dassey, correct? And he says correct. Question. In fact, you may never have met him until today, correct? Answer. Correct. And as part of your assessment, since you are a social psychologist, I'm going to assume that you conduct no psychological tests or have conducted them on your behalf involving Mr. Dassey. Answer. Correct. So no MMP, is that P? Yeah, PI, no Oshkosh, suggestibility scale, etc. Answer. Correct. Okay. You yourself did not perform, nor did you ask anyone to conduct any intelligence tests on Mr. Dassey, correct? Answer. Correct. Question. So I believe then, did you, however, indicate that you reviewed Dr. Gordon's report, or what, or not? Answer. Correct. I did last night. Yes. Question. Okay, last night. Answer. Correct. Question. You didn't review his testimony? Correct. Okay. Anything else of what Mr. Gordon did in this case that you might have reviewed? Answer. Not that I recall, no. Okay. And in this particular case, you reviewed all materials that were submitted to you by counsel for the defense. Answer. Correct. Question. Did you make any additional requests for information? Answer. Dr. Gordon's report, I think, was the only one. Question. All right. You didn't ask for any additional media reports. They were just given to you. Answer. Correct. Question. Okay. So it's fair to say that the only materials examined outside of this directly related to the Dassey interviews conducted in November, February, March, and May were the trial transcripts and the reports of Dr. Gordon and the media reports. Answer. I'm not sure I understand your question because there's also reports by White and Buckley, and then there's also police reports. I'm not sure. Maybe. Question. All right. Answer. I just didn't understand your questions. I don't know where Fallon's all over the place. Question. Well, that's fair. You looked at those but that's pretty much the focus, as it were, of your examination. Answer. Yes. Okay. All right. Now, Exhibit 316, would you like me to turn to it if you wish? Okay. And that binder is in question. I believe that would be binder 5. I believe that's the one that summarizes your testimonial experience or professional consultation experience. Question or answer. Okay. I would like to talk to you a little bit about what you said. 316. You have it? Yes, I do. Okay. Now I understand. Well, let me ask this. In the past 2 years, approximately, how many times would you say you have testified in court of law regarding this subject matter? 2 years, January 08 to January 10. Question. All right. And in my estimate would be 25 to 30 times. That would be my guess. Maybe a little less, maybe a little more. Question. And since August of 1997 through December 2009, which I would cover a little bit more before that, 12 and a half years, you would tell us you've testified approximately 187 times in a court of law. Answer. Correct. Question. All right. So that's about 15 and a half times per year. And he said, I think that's a roughly right. Question. All right. So in other words, you're testifying in court of law on material on the average of more than once a month. Answer. Correct. Question. And as a matter of fact, you indicated you were just here in Wisconsin a month ago. Correct. In Chippewa Falls. Correct. That did not go well for you, right? Answer. Well, for me, it went fine. It didn't go well for the defendant. Question. You also indicated that you testified in 111 trials. Correct. So that means you're testifying at least over 9 times a year in a trial where the issue of whether or not a statement is a false confession or not has become an issue. Mathematically averaged out, I think that's right. 65 motions and suppressed that you've offered testimony. Correct. And 11 post-conviction hearings. Correct. Now, I'm assuming that the vast majority of these testimonies experience come from the state of California. Would that be correct? Yes. And I believe you indicated on direct examination that for you to consider a consultation, you don't just consider it a consultation unless you actually reviewed materials that are compensated for your work. Question, answer, or I've agreed to the pro bono, but yes. Question, okay. Now in this particular case, you've advised us that you're compensated $250 an hour. And how long have you been compensated at that rate for your advice and consultation in cases such as this? $250 an hour, and that was in 2010. I am in the wrong business. I tell you what. Caregiving does not make money. Mose can tell you that, right, Mose? Since 2001. Okay. All right. Now, as I understand it, you've consulted in 47 states and the District of Columbia. Answer correct. In 12 years, almost 12 and a half years now, that we've examined this material, you consulted, as you said, 1,132 times. Or does that consult include testimony, or is that consultation in addition to testimony? A. No, that's all cases that I've reviewed. The 100, that includes the testimony. Yeah. 187 cases are a substate of the 1,132 cases. Question. All right. So that's about 80 to 100 cases consultation. It's a year. Answer. Correct. I know where he's going with this. I just don't like it. If you mathematically average it out, yes. Right. Now, when you're asked to evaluate a case, your role is primarily that of interpreting facts and offering opinions based on those facts, correct? Answer. Well, I think about it as consulting and offering opinions. So some sort of professional assessment and evaluation as well, yes. Refresh. Question. Well, that can only come from a review of whether are believed to be known facts in a given case. Answer. Correct. Or the facts that I'm being told, yes. Question. All right. And thus you're offering opinion based on your training and skill, which interprets that you think the meaning of those facts may be. Answer. Correct. Question. Okay. Now, unless one can actually demonstrably prove that a confession is false, then what your role is in a case is given simply to interpret those facts and in essence give us an opinion or a judgment as to whether certain police techniques were coercive and could have led to a false confession, correct? Answer, yes, but sometimes there's more than that because I have idiosyncratic facts where may have some nuances aspect of this research or this area of expertise that a particular attorney is asking for an example about or possibly expert testimony about. Question. All right. But if you're not allowed to offer an opinion, for instance, that certain police tactics could have led or were in fact coercive and could have led to a false confession, there would be no role for you otherwise, right? Answer. No, I would disagree, and much of the testimony could be general. It could be about frameworks or for understanding on how interrogation works or what we know about the phenomenon of false confession. So I don't think your characterization is inclusive to all possible applications of this kind of experts. Question. All right. In your testimonial experts, do you charge more for the testimonial experience or is it the same fee for time invested? Answer. No. I charge for one rate for my time. Question. All right. One rate. Meaning $250 an hour is my standard rate. Question. And then change the rate for testimony. Yeah, correct. Question. Very good. All right. Well, let me ask this. Generally, would you agree that cases of psychological coercion by the police constitute a minority of the cases in criminal justice system? Answer, yes. Question, would it also be fair to say, would it not, that the frequency of interrogation-induced false confessions is completely unknown? Answer, correct. There's no scientific way of estimating it. Question, as a matter of fact, there's an opinion that you reached in a law review article entitled, The Problem with False Confessions in the Post-DNA World, correct? Answer, I don't remember if we mentioned that in the article. It's certainly possible. Answer, or question, if I remember correctly, you also opined that the percentage of interrogation-induced false confessions leading to wrongful conviction is likewise unknown. Answer, correct. Question, have you worked with Northwestern Law School Innocent Project prior to this? That's Steve Drizzen and Laura Nyrider's organization that represents Brendan. Answer, you mean as a consultant on a case? Question, yes. Answer, I don't believe so. Question, all right. Have you worked with other Innocent Project staffs around the country? Answer, I have, yes. Question, all right. And how often? Answer, I guess I have worked on a dozen cases. I'd have to look through my records, but maybe one case or 2 cases a year for the most years, not all years. Question, as a matter of fact, you collaborated with Mr. Drizzen on a number of research projects, correct? Attorney I guess he mispronounced his name wrong, because then Attorney Drizzen. Just for the record, Judge, it's Drizzen. So he must have pronounced his name wrong. That's shitty. Fallon, that's a shitty move. Fallon, very well. Witness, it's by Attorney Fallon. Mr. Drizzen on a number of projects. Answer, yeah. We've written 2 articles together and 1 chapter for an edited volume, correct? Question, I'm sorry, 1. Answer, 1 chapter for an edited volume. All right, you wrote the North Carolina Law Review article with Professor Drizzen. Correct. And as I understand it, you also wrote an article that was published in the University of Wisconsin Law Review in 2006 with Mr. Drizzen. Correct. Oh, gotta refresh again. We're almost done, guys. We're on page 273 out of page 291, so we're doing really good. We're almost there, I promise. At least for day 2. Next Saturday we can start day 3. How exciting! I believe there's 5 days in total. Sorry, I'm just stretching my back. I don't like just sitting. The reason why I only do hour, I try to do only an hour, is because I don't like sitting in one spot for too long. I get very antsy, and I have to move around. So that's what, right now I'm kind of moving around. Okay. Question. I believe also that you've more recently published, at least the online version is available, Police-Induced Confessions, Risk Factors and Recommendations, and Law and Human Behavior. Answer. Yes, well, actually that's 4. I've had remembered 3. So that's correct. So that would be 3 articles in 1 book chapter. Question, that's due to be actually out in print form later this year. Answer, correct. Question, all right. Well, I'd like to talk to you, Doctor, about the research, if we could. And I'm going to begin with discussion of your research that you reported in North Carolina Law Review with Professor Drizzen. All right. Answer, okay. Question. Now, in particular research, I think you testified to this today, that you told us that there were 4 types of cases which one could legitimately say a confession was false, correct? Answer, yeah, but I characterized it a little bit differently, that you could prove the confession false to near absolute certainty. Yeah. Question. And I believe those four were that an individual confesses to a crime and, for instance, the crime confessed to had never occurred. Answer correct. Question. Another example would be the evidence objectively establishes the suspect or defendant could not have committed the crime in question. Answer correct. And then a third type of case is where the true perpetrator of the crime is identified and in reality his guilt can be objectively established and proven. Answer correct. Question. Then finally, the most common form would be scientifically exoneration. Answer. I think that's the form, yes, that we know most about. We hear most about. But actually, I think the most common would be the one where the true perpetrator is identified and apprehended. Interesting. Question. And subsequently, people are able to prove him guilty beyond a reasonable doubt. Answer correct. Question. Okay. Now, is this not one of those cases? Answer correct. Question. So we cannot say that this confession is, in this case, is demonstrably false. Answer. We can't categorize it as a proven false confession if we were going to write about it for an academic purposes. Correct. Question. Right. Now, in the research that you conducted with Professor Drizzen, I believe, as you say in your world, the end was 125 cases, correct? That's the way of putting it. Answer, yes. Question. All right. And in that research article, you made a number, or you discussed and offered a number of both qualitative and qualitative trends you detected. Answer correct. And would it be fair to say by the way, that the research is descriptive study, is it not? Answer yes. Now, in terms of the qualitative, hold on. Copy. What does this word mean? Google? Paste. Rating to measured by the quality of something rather than its quantity.
Qualitative.
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 Thank you, Google. In terms of the qualitative trends, you indicate that youth or one of youth age was overrepresented. Answer correct. In your sample, correct. I believe you said that those under 25 constituted 63% of your sample, right? Answer. I don't recall the specific number, but if that's the article reports, then that would be accurate. Question. All right. And in your sample, those were 16 to 17-year-old constitute about 16% of the sample. That was based on 18 out of 130 from whom you've actually had the ages. Answer. Again, I don't, off the top of my head, I don't remember the percentages. Question. If I were to give you a copy of the article, would it help as we discuss it? Answer. Yes. It would help me verify what's published in the article. Sure. So then they give Exhibit 365 marked for identification. May I approach? And then the court says, go ahead. Doctor, I show you that's been marked as Exhibit 365, and I give you a moment or two to look at it and make sure we're talking about the same piece of research. And then he says, yes, this is the North Carolina Law Review article downloaded from Westlaw. Question, all right. And I believe you talk about these qualitative trends several pages in. How about beginning page 22 and 23? Okay, we're talking about the Westlaw page citation. All right. Yeah. So we're discussing 16 to 17-year-olds in your sample constitute 16% of those who have participated in the case in which their confession was demonstrably false. Correct. And that 63% or 71 out of 113 were age 25, right? And he says, no, I don't think that's right. Under age 25, I think is 63%. Yeah, 63%. Okay, I thought you said 73. Maybe I misheard. You said 71. No, I said 71 out of 113 comes to 63%. Oh, okay. Sorry. Right. Yeah. Okay. And from this, you make several conclusions or observations that youth or one of the young age that is a risk factor that should be taken into consideration in evaluating statements. Answer, yes. We described that, yes. Question. All right. Well, as a social psychologist, let me ask you this, doctor. Have you been to a prison in America lately? Answer. Depends on your definition of lately. I think the last time I went to prison would have been December 2007. Answer. All right. Would you agree, would you not, that the vast majority of offenders are young offenders in American prisons? Attorney Drizzen. I would object. You know, what does young mean? Witness, yeah. Fallon. All right, all right. If you want some ages, we'll get some ages on there. Let's start with the vast majority of men in prison in the United States are clearly under the age of 40, right? Answer. I mean, I believe so, but I would want to go into the Department of Justice or Bureau of Justice statistics. Question. Would it be fair to say, based on your own academic experience, that the largest amount of men in prison are probably ages 18 to 30? Would you wouldn't quibble with the generality, would you? Dun, 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 dun. I wouldn't quibble with it. I just want to get the actual statistics. He's a scientist, Fallon. That's how they think. Question. Now, so tell me then this. What is the percentage of offenders under the age of 25 that would have truly confessed to the crimes? Answer. Well, this is only a study of false confessions. It's not a study of true confessions. And these are only numbers from the study of false confessions. So that may not be, that may or may not reflect all false confessions. I don't know the answer to your question. All right. You don't know the number of those under 25 who truly confess to the crimes. Answer. Correct, because we don't know. We don't know how many people have truly confessed. There's the department, the government doesn't keep records of this, so we don't know any age. You can't answer that question for any age. Question. That's correct. You cannot answer it. That's the percentage of offenders under the age of 40 who have provided true confessions, correct? Answer. Correct. And question. You don't know that, correct? Correct. So, doctor, you can't say with any degree of certainty that young age necessarily that young age necessarily discriminates between those who give true confessions and those who give false confessions. Answer. Correct. You can't take the fact that someone's age to say that it will tell you whether or not a confession is true or false. Question. Because you have nothing to compare your descriptive study with. In other words, there is no group of individuals known to have truly confessed. Answer. Well, I agree with your conclusion, but I disagree with your reasoning. Even if you had that information, you still wouldn't be able to say because somebody's age that the confession itself is true or false. You have to do the post-admission narrative analysis that I described earlier. What youth gives you a risk factor. For examining, for explaining why somebody would have falsely confessed. But it doesn't discriminate between true or false confessions. In your question, in your research, you also talk about length of interrogations, correct? Answer, yes. Question, and I believe, as I understand it, you opt in that the average length of interrogation led to a false confession was 16.3 hours, correct? Answer. In this study, for the cases that we had that data, yes. Question. Where you had demonstrably false confessions. Answer. No, no, no. where we had information about the length of interrogation because we didn't have it. We couldn't get it for all the cases. Question, right. So you're, and as it were, less than 125. Answer, correct. Question. Now, as a matter of fact, in your recent publication from the summer of Law Human Behavior, the online publication, and the article Police-Inducing Confessions, Risk Factors and Recommendations, you also, again, refer to the fact that most of the false confessions occur in cases where there's been 16 hours of interrogation on average, correct? Answer. I think it refers to this study as part of the discussion about how length is a risk factor in interrogation. Question. Now, in this particular case, the questioning of Brendan Dassey was not lengthy in any of those interviews, correct? If you take them individually, no. And certainly not 16 hours. But if you add them together, then yes. Question. All right. Well, let's talk about that. He was questioned on November 6th. Do you know how long? Answer. No, I don't recall off the top of my head. Question. Would you quibble with Would you quibble with 53 and a half minutes? Answer. Because I don't remember, I'm not going to quibble. Question. How about November 10th, 2005, questioning law enforcement? Answer. No, I don't recall. Question. I believe the reports that you have read suggest that the interview occurred from 12:05 to 12:30. So my calculation about 25 minutes. Answer. If they're accurate, that would be my calculation too. Question. But you don't review the transcripts or listen to the audio of those questioning sessions, did you? What? Answer. I don't believe I did. I'd have to double check, but I don't believe I did. So you have no idea as to how confrontational or non-confrontational or what tactics or what techniques may have been used in those interrogations, right? Correct. If I didn't review them. I do want to pause and say that while Dr. Richard Leo may have not have heard the actual recordings of the interrogations and just read the transcripts, so he's basing his professional opinion on reading transcripts. Now, Fallon is trying to argue that you don't know the context of those discussions because you didn't hear it in their voices. Like, were they yelling or whatever? He's basically trying to say that because he didn't listen to the tone of their voices, and how can he say that they were bullying or coercive or whatever? Now, that being said, we know, we the public have heard these by now, so we know exactly how those interrogations went down. And yes, they were coercive, but for the purposes of this, he's basically trying to disprove Dr. Richard Leo's professional opinion by saying that it was a biased opinion of some sort. He also brings in the question that he's a paid specialist, which I argue this a lot because, like, for instance, charity work and all that, people got to pay their bills. So just because he's being paid to give an opinion doesn't mean his opinion is any less valuable. Just like how you pay anybody to do anything for you. People got to pay their bills in life and take care of themselves and their families. So I just want to bring that up too. Question. Now, with respect to the questioning at the school on February 27th, do you recall how long the interrogation was there? Answer. I think it was around an hour and a half, but I could be misrecalling. Question. And I believe that's exactly on an hour and a half. There was a break after 60 minutes, right? 5-minute break. Answer. I don't recall specifically but if it's there, then yes. Question. And there was another break devoted to writing a statement that was about 15 minutes long, where after the break he was writing a statement, correct? Answer. You might characterize that as part of the interrogation process. Question. But there wasn't a lot of active questioning. Answer. Correct. Correct. There. No back and forth. The statement at the Two Rivers Police Department was actually 41 minutes, right? Answer. I don't recall specifically, but if that's what the records indicate, then yes, I thought it was a little longer, but I could be misremembering. Question. Now, with respect to the March 1st statement, talked a little bit about that. Before we get into details of the statement, I want to talk just generally context and time. How much time did the office actually spend with Mr. Dassey before he confessed to the events which were subject to this hearing? Answer. Well, you're talking about the March 1st interrogation. I have to look at it to give you a precise answer. I don't recall. Hey, Jasnaz. I don't recall specifically the length of time off of the top of my head. Question. Well, based on all the materials that you reviewed, including the clips that were just played for you during the direct examination, would it be fair to say that Mr. Dassey pretty much had given all up in the first 90 minutes of that interview, right? I'd have to look it over to confirm that. Question. Well, I believe the tape begins on 10:52, and I think some of the first clips were played for us today began at 10:58. And there was a break at 12:28, was there not? Answer. Well, again, I don't know if this information off the top of my head. I have to look at the record to confirm that. Question. I'm sure you'll have an opportunity tonight. Will you do that for me? Answer. Sure. Thank you. And during the course of that break, after the first hour and a half, Mr. Dassey, there's about a half an hour break. He's offered food, drink. In fact, he's actually telling the investigators that he's feeling pretty good, correct? Answer. Again, I'd have to review that, which I'm happy to do tonight. I just don't recall off the top of my head. Question. All right. So, all right. Then I guess I'll wait for you to review so we can finish up with more of these detailed questions tomorrow. But let me ask this question, just like the age factor, the length factor of interrogation at risk, the length of the interrogation as a risk factor. You can't tell us the average length of interrogation that leads to a true confession, can you? Answer. No, we can't tell you that, but we estimate it to be around an hour or so based on the field studies and surveys of police, but really nobody knows that. Question. And so you can't really say that longer interrogations are over or underrepresented or over or underrepresented with false confession. Answer. Well, if the surveys are accurate and if the field studies are accurate, then we could say that, yes. All right, let's talk about some of the qualitative findings. I believe they are qualitative findings in this case, or excuse me, in your research. In your research in that article, which I think you follow up and confirm in the Law Human Behavior article from the summer, you tell us that low intelligence is a risk factor. Answer. Correct. Question. In your sample of in the North Carolina, I'm going to refer to it as a study. I'm sure it's not North Carolina study, but in the study referred to in the North Carolina Law Review article of that 125 or whatever the number was, for which you had intelligence data, that was the average, or how many people in the sample had an IQ below 100. 100 is the average. 99 to 100 is an average IQ for everybody. Answer. I don't know how many people have an IQ below 100. I don't even think we asked that question. I think we were interested in the question of how many had an IQ of 70 or below and were defined as mentally retarded. And I know that is somewhere in the article, but I'm not sure if it's in the table. Question. How about in the back? Keep going further through. There's a discussion regarding mentally retarded. I'm not getting to that yet, but that's coming up. The court. Do you have a page you can turn to, Mr. Fallon? I might be able to help him out there, Judge. Witness. I think you're talking about page 35. I think that sounds right. Yes, I am. Exactly. Okay, now, is there a pending question? Ugh, we're almost done. We're on page 288 out of 291, so we're getting really close, guys. Yes. I know you look for intelligence quotients or data reflecting cognitive abilities for individuals who are believed to be mentally retarded. Question. Or low-level cognitive function. Yes. Or low-level cognitive function. Believe it or not, there is a difference between mentally retarded and low-level cognitive functioning. Yeah. Question. Well, what about individuals who are in that category? In terms of your data for that study, of those who weren't mentally retarded, how many of them had a low quotient of, let's say, 75? Or functioning at a level of 75 to 85? Answer, I don't know. We don't know. Question. Okay. What is the average cognitive ability or IQ quota to be redundant, I guess, of an individual in cases who are truly confessed? Answer. Well, again, we don't know. What? Because we don't have a universal case of true confessions. Question. All right. And the reason is because there's no real control sample with the study. Answer. No, the reason is because nobody's gathered that data. The government doesn't keep those kinds of records on true confessions. Pow. But in research, as a researcher, as a social psychologist, there are some kinds of studies in which we actually have them stand for the proposition that you would like them to stand for. Would you need to have a control sample to compare data? Answer. Yeah. You're saying very, very generally yes. Question. All right. And in this particular case, you did not have a control sample. Answer. Well, I don't think in this case it's necessary to have a control sample. The point that we're making is that relative to their numbers in population, they vastly disproportionate in the population of proven false confessions. Question. But doctor, you can't tell us whether low intelligence, length of interrogation, or age truly discriminates between leading to a false confession or a true confession. Answer. No. I can tell you that it does not discriminate. Right? The same answer as before. These explain why somebody would give a false confession. They are risk factors, but not that they won't tell you in the end themselves that the confession is false. Question. But you still don't know if they really are a risk factor because only that they are described is found in your study. You have nothing to compare them with. You have no control sample to compare them with of known true confessors to discern whether or not youth or cognitive ability or length of interrogation. Ah, Cheeto! No, Cheeto. He's walking on the keyboard. Don't do that. Only that they are described and found in your study. You have nothing to compare with. You have no control sample to compare them with known true confessors to discern whether or not youth or cognitive ability or length of interrogation are correlate directly with false confessions. Answer. No, I disagree with you. I can explain my disagreement, part of which I already done, but no, I disagree with that. And then we have the court. Mr. Fallon, is this a good point to end it for the day? Attorney Fallon, as good as any judge. The court, all right. It's 8:30 tomorrow. And then they stop at 4:30 p.m. So we are officially done with day 2. What do you think, Cheeto? I think he's trying to basically say that Richard Leo's opinion maybe does not have grounds for being a scientific opinion, but most, I don't know. He's trying to argue his validity of his opinion. Which, to me, so far, it sounds like it's going around in circles. And, but I guess we'll see what tomorrow brings. But we're going to stop here, too. I mean, next Saturday, we will discuss, or we will continue. It's been almost 3 hours. This is longer than I've ever gone live for, I think. So thank you to everybody who stuck it out with me and who's listened. And today is popcorn day. So if you guys want to get a bag of popcorn, I'm going to turn on Making a Murder and start streaming it again. But I'm going to have it on mute unless I look up and I see something, and I might record it like I did last night. But I'm going to read my book and eat popcorn. And I hope everybody has a great day. Trying to think of, stream Making a Murder event, eat popcorn, and Brendan's still looking forward. He hasn't, like I said, I talked to him this morning. He's doing very good, very excited about tomorrow. And he's excited about future visits with his mom because of the food kitchen that's opening up. And he's excited for French fries. I'm kicking around an idea of doing a fun food event for him that's a little bit off, where we all eat French fries one day. Maybe next, like I'll talk to him more about it. But So yeah, he said he's still waiting on, he still hasn't gotten the sweater competition pictures yet. So if you guys, thank you for your patience on all these things. The mail has just been terribly slow, and so is the company that does the mail for the prison that Brendan's at. So thank you again for your patience on that. But he is excited to be getting that. So, and yeah, I think that's all I really have, and I'll talk to you guys, I believe, Monday when I read from the book that we've been reading from, Anatomy of a False Confession. And I think once I'm done reading that book, I'm going to read that other book that they mentioned in this trial. I think that's interesting. And I this has all been very fascinating learning about, and I hope you all are having not fun, but I hope you all are fascinated by what we're learning too through all of this. I think that it's important because it answers the old question that I constantly hear. Well, why would Brendan confess to something that he didn't do? Well, we're learning why. So there you go. All right. Let me see. What should we close off on? This is always a goodie.
You were appointed, was it on March 7th or March 8th?
March 7th.
March 7th, okay. Did you talk to Brendan on that day on March 7th?
I don't believe I did.
Okay. However, you did talk to the press, is that right?
Yeah, shortly after the appointment, the calls started rolling into the office.
Sure. I want to draw your attention to a news report from Channel 26 that says we have a 16-year-old who, while morally and legally responsible, was heavily influenced by someone that can only be described as something close to evil incarnate. Right?
That's what it says I said, but that wasn't me.
Okay. Is there anything about this statement that bothers you?
To say that we have a 16-year-old who's morally and legally responsible, that would in effect admit guilt, and that is something you should definitely not say.
Just for the record, Your Honor, Mr. Kaczynski testified that he did not make those comments, and this exhibit is being introduced as impeachment evidence to demonstrate that, in fact, Mr. Kaczynski made those comments.
court will receive it.
Attorney Lynn Kaczynski immediately lashed out at Stephen Avery.
We have a 16-year-old who, while morally and legally responsible, was heavily influenced by someone that can only be described as something close to evil incarnate.
And the next day, you make the statement that if the confession is valid and admissible as evidence, it would almost certainly result in a conviction. Am I correct? Okay. You still haven't reviewed Brendan's statement, right?
No, that's correct.
First statement?
Correct.
All right. March 10th,